A lot of professionals assume they qualify for an intercompany transfer to Canada. They have a strong title, they work for a multinational company, they have been there for years. So they apply and then they get refused. Not because the company isn't real, not because they lack experience, but because they misunderstood one critical requirement. And that refusal does not just cost time, it can delay a Canadian expansion. It can derail a product launch. It can eliminate a career-defining opportunity overnight. Since the October 2024 rule changes, the bar for intercompany transfers is higher than most people realize. I'm Evelyn Ackah, a Canadian immigration lawyer with over 25 years of experience helping clients just like you. And today, I'm walking you through exactly who qualifies for an intercompany transfer in 2026, what has changed, how the application works, and the mistakes that get strong applicants refused. Because this pathway is powerful, but it is not forgiving. The mistake that gets most people refused. A lot of professionals assume they qualify for an intercompany transfer to Canada. They have a good title, they work for a multinational company, they have been with the company for years. So they apply, and then they get refused. And the refusal does not just cost time, it can stall an entire Canadian expansion. It can collapse a product launch, and for the worker, it can mean watching a career-defining opportunity disappear. The Intercompany Transfer Work Permit, also called the ICT, is one of the most powerful immigration pathways into Canada. It is LMIA-exempt, which means your employer does not have to go through the long, expensive labor market impact assessment process to prove that no Canadian could do the job. That alone saves months. But here's the problem. Because the ICT sounds straightforward, people underestimate how strict the requirements actually are. And after the October 2024 rule changes from IRCC, the bar has gotten even higher. So let me walk you through exactly who qualifies, what the new requirements are, how the application process works, and the mistakes that lead to refusals so you can avoid them. Who actually qualifies for an intercompany transfer? The Intercompany Transfer Work Permit is part of Canada's International Mobility Program. It is designed for employees of multinational companies who need to move from a foreign office to a Canadian office. But it is not open to just anyone inside the company. There are 3 categories of workers who qualify. First, executives. These are people who direct the management of the organization or a major part of it. They set goals, they make high-level decisions, and they have broad authority. Second, senior managers. These are people who manage a department, a division, or a function of the business and supervise other managers or professionals. Third, specialized knowledge workers. This is the category that causes the most confusion and the most refusals, quite honestly. Specialized knowledge does not mean you are good at your job. It means you have proprietary knowledge of the company's products, services, processes, or procedures that is not easily found in the Canadian labor market. After the October 2024 changes, IRCC now requires that specialized knowledge workers demonstrate both advanced expertise and company-specific proprietary knowledge. Knowing how to do the work is not enough. You must prove you know something that the general Canadian labor market does not. Here's the other critical requirement. You must have worked full-time for the foreign company for at least 1 continuous year within the last 3 years before you can apply for intercompany transfer. Part-time work does not count. Contract work generally does not count. And the company itself must be a genuine company, corporation. It must operate in at least 2 countries with physical premises in each. That physical premise requirement is now required. It has caught a lot of applicants off guard. The multinational corporation is required for every citizen that is not American citizen. American citizens still can qualify with having their U.S. company and their new Canadian company, but all other citizenships must have a multinational corporation. Here's the good news. Because the intercompany transfer is LMIA exempt, you skip the most time-consuming part of the Canadian work permit process. There is no job advertising requirement. There is no labor market impact assessment. That can save you 4 to 6 months compared to a standard work permit to get started. Instead, your employer submits the offer of employment through IRCC's employer portal, and they pay the compliance fee of $230. The offer needs to clearly show your job title, your duties, your salary, and why your transfer serves Canadian interests. Once it is submitted, you as the worker can apply for your work permit either online through a visa office if you need a visa to come to Canada, or if you're a citizen of a visa-exempt country, you can apply at the port of entry upon entering Canada. Processing times vary. U.S. citizens applying at the border oftentimes will get approved the same day. Applicants from other countries, however, must apply through visa offices. It can be anywhere from a few weeks to several months, depending on the visa office. Indian nationals who represent one of the largest groups of intercompany transfer applicants have reported processing times of 3 to 6 months through certain visa offices. But here's what matters most. The speed of your approval depends almost entirely on the quality of your documentation. A clean, well-prepared application with strong supporting evidence can move quickly. A weak one gets flagged, delayed, or even refused. The documentation that makes or breaks your case, this is where I see the most heartbreak. Smart, motivated professionals and well-meaning companies submit applications that fall apart because of documentation problems. The number one reason for intercompany transfer refusals is failure to prove the corporate relationship between the foreign company and the Canadian entity. You need organizational chart showing the reporting structures across both offices or multinational offices. You need ownership documents, corporate registrations, articles of incorporation, and proof of shared ownership or control. If you're setting up a new Canadian office, you need a detailed business plan, a commercial lease, proof of funds, and evidence that the Canadian operation will be real and ongoing. The second most common reason for refusals is role miscalculation or misclassification. People call themselves executives because it sounds important, but Canadian immigration officers know what a true executive actually does under the legal definition. If your day-to-day work does not match the title you are claiming, your application raises a red flag. The same applies to senior managers and specialized knowledge workers. If you are a specialized manager and you don't supervise other managers or professional staff, you're not considered senior manager in the eyes of immigration. For specialized knowledge workers, the documentation burden is even heavier. After the rule changes, you now need to show that your knowledge is both proprietary and advanced beyond what a similarly qualified Canadian worker would possess. Generic job descriptions will not cut it. You need specific examples of projects, systems, or processes that only you can execute for the Canadian operation. And do not overlook the wage requirement. IRCC now expects specialized knowledge workers to be paid at or above the prevailing wage for their occupation and region. Underpaying signals that the role may not actually require the level of expertise being claimed. Officers do not approve these applications. They don't like them. They either believe your story or they do not believe your story. Every document either supports your case or undermines it. There is no middle ground. What happens after you arrive? Landing in Canada on an intercompany transfer work permit is a major milestone, but it is not the finish line. What you do after you arrive determines whether this becomes a temporary assignment or permanent life in Canada. First, make sure you are actually doing the job described in your work permit. Immigration officers can and do request proof that you are fulfilling the role you claimed in your application. If your job changes significantly and you do not update your permit and the employer compliance portal, you risk falling out of status entirely. That is not a technicality. That can end your time in Canada. Second, your spouse or common law partner may be eligible for an open work permit, which means they can work for an employer in Canada, assuming your position is a skilled one, and your dependent children can attend school. The whole family can settle together, and that stability matters when you're building a life in a new country. Third, start thinking about permanent residency from day one. Most intercompany transferees qualify for express entry under the Canadian Experience class once they have 1 year of skilled Canadian work experience. Provincial nominee programs are another strong pathway, and your Canadian employer can support your application with a permanent resident job offer for additional CRS points. The intercompany transfer work permit is renewable. Executives and senior managers can hold them for up to 7 years. Specialized knowledge workers can hold a work permit for up to 5 years. But the real opportunity is not the work permit itself. It is using that time to build the Canadian experience, the professional network, and the immigration profile that leads to permanent residency and eventually citizenship if that's what you choose. I've seen clients arrive on intercompany transfers and within 2 or 3 years become permanent residents and within 5 or 6 years become Canadian citizens. running their businesses and hiring Canadians. That transformation from temporary transferee to permanent Canadian is not unusual, but it only happens when you plan for it from the beginning. What to do next? You now understand how the intercompany transfer work permit actually works in Canada, what the new rules require, and what causes refusals. Whether you are a company expanding into Canada or a professional preparing for a transfer, this program can change the trajectory of your career and your business and your life, but only if you get the documentation right and the strategy right from the start. Now, for some companies, especially in the tech sector, the intercompany transfer may not actually be your fastest option. Canada has a program called the Global Talent Stream that can get a work permit processed in just 2 weeks. If speed is what your business needs, you do not want to miss my next video on how the Global Talent Stream works and who qualifies. I will see you there.